Please be seated. The court is now back in session, and I'd like to ask whether judges of the bench have any questions for these two medical experts. And at the commencement of the hearing on the 21st January 2015, the trial chamber advised the parties that the fitness to stand trial of the accused is to be held on the 23rd January 2015, and parties are instructed to provide any confirmation by afternoon of the 22nd if any party wish to have the hearing held. And yesterday we received confirmation from the lead co-lawyers for civil parties to put questions to the expert in relation to certain paragraphs of the report. And for that reason, the chamber will cede the floor to the lead co-lawyers for civil parties to put the questions to the two experts, and you may proceed. Good morning, Mr. President, Your Honors. And due to the privacy and confidentiality of personal information of the accused, we will not put questions in relation to that, and most of the questions have been put to the two experts by Judge Friends already. And I have one question which is in general to be put to the medical experts. For people with high blood pressure, and when they face an issue, to make them, for example, shocked or feel really unhappy or upset, or maybe a question would upset that individual. My question to the two experts is the following. Will people or individual with history of hypertension is affected by such situation, and in terms of mental status, and if so, how?
Mr. President, I wish to answer that question, which is a general question about how people would react if they have high blood pressure when they are shocked, unhappy, or upset. I think the response of such an individual would be a further rise in his or her blood pressure, and depending on the intensity of that shock or unhappiness, sometimes it can be a triggering factor for them to develop severe uncontrolled hypertension or even hypertensive crisis. Now, in hypertensive crisis, we are really talking about a blood pressure that is above 180 systolic and or a diastolic that is above 120. In such a situation, if the pressure is above 180 systolic and or a diastolic of above 120, the person may develop a condition called hypertensive encephalopathy. That happens when the pressure is so high that it causes swelling of the brain, and as a result of the swelling of the brain, that person can develop acute confusion, and the person may develop a stroke in the process. Of course, when the person becomes confused, incoherent, unable to recognize people, it is a medical emergency where they need to be brought straight away to the hospital.
Thank you, Mr. Expert, for your response. You talked about the severity or the intensity of the hypertension. Would you be able to provide further details on the level of intensity that would cause the hypertension or leads to hypertensive crisis?
Well, I'm afraid this is very individualized. There are some people who are very resilient and nothing can shock them. There are others who are very sensitive, and certainly any anxiety could trigger a rise in blood pressure. I have to add that not every blood pressure that is above 180 over 120 will lead to hypertensive encephalopathy. Some patients will, for some reasons. Some patients will not, for some reasons. I think there's also individualized and probably has a genetic basis to that.
In order to avoid the level of hypertension that might lead to a severe crisis, would you have any recommendations to make to prevent such occurrence?
I think the recommendations to prevent such an occurrence would first and foremost be to have the normal, his usual blood pressure of the person to be well controlled first. If the person at rest and in a very relaxed state still has high blood pressure, then obviously it would be much easier for that pressure to go up upon provocation compared to someone whose blood pressure is within the normal range. So that would be first and foremost the most important thing to avoid a person from developing such a hypertensive emergency. The others would include very basic healthcare, very basic healthcare precautions like a proper diet, low salt diet, as well as adequate exercise and adequate rest, of course.
I have no further question for Mr. Expert, and thank you for your response, and thank you, Mr. President. President, and what about other parties through the proceeding? Do you wish to put questions to the expert and the International Court Prosecutor? You have the floor.
Thank you, Mr. President, Your Honors. Thank you, doctors, for coming. I'd like to just ask you a few questions about material that you reviewed in preparing your report. And in all of the questions I'm going to ask you, I want to distinguish between questions about the general medical condition and care of the accused and questions directly relevant to their fitness to stand trial. Did you have the opportunity, or were you provided by anyone with the chance to observe the accused Nuon Chea and Khieu Samphan's statements to the court at the very end of the last trial, Case 2-1, in October of 2013, where they each addressed the court in some detail about their views of the evidence and the trial?
Yeah. No, we have not.
Did you have the opportunity, or were you provided by anyone with the opportunity to review statements made by Nuon Chea and Khieu Samphan in October and November of 2014, when they explained that they each had instructed their counsels to boycott the proceedings until various conditions they demanded were met, and explained their reasons?
No, we have not.
President and Madam Counsel for the defense, you may proceed.
Thank you, President. At this stage in the proceedings, I have some questions with respect to the co-prosecutor's line of questioning. I do not see any link whatsoever between what the medical experts have to say and what he referred to as the accused's availability to attend the proceedings. They have never said that they were unable to follow the hearings. I think questions should be focused strictly to what the experts have been summoned to speak about.
Thank you, Your Honor, and I absolutely appreciate counsel's comment. That's exactly my point, one that I wish to make, that no one, including defense counsel, has said that the accused are not fit for trial, and that is the exact purpose of this hearing, to assess their fitness for trial. So I appreciate that point. Can I go on in my questioning? Sir, in regards to what you were able to review about the current medical care given to Khieu Samphan and Nuon Chea, can you compare that to the general population and perhaps even your own patients as far as the access that they have to regular medical care?
Mr. Expert, please hold on, and the counsel for the defense, you may proceed.
Once again, Mr. President, thank you. I can see where the co-prosecutor is coming from. If he has a speech or submission to make on the medical condition or healthcare system in Cambodia, this is not the appropriate place to do so. The medical experts are here to talk about the medical conditions of the accused, and that's exactly what the co-prosecutor must focus on, otherwise his remarks are simply inappropriate.
my question's directed specifically to the medical care of the accused, and this relates specifically to the issue that one of the doctors raised about the amount of reviews that should be done and the frequency of reviews of their mental conditions.
President, the Chamber wishes to hear the response from the experts to the last question asked by the International Co-Prosecutor. And Mr. Expert, you may respond to the last question. Answer. I would like to respond to the last question asked by the Co-Prosecutor. In our recommendation, we recommend for a regular review through the mental status of the accused. And it is my observation that the court invited the experts to have a regular review annually or about annually. However, we have not received any regular medical report from the hospital on the mental health. We only have the physical medical report in the form of a daily report or a weekly report, but none of the mental health report. For us, it would be better if we are able to access to that so that we can use them as a reference in our report or an assessment. And if not, we can only rely on whatever reports that we may have. And when we ask the treating doctors or the duty doctors, their impression on the mental health of the two accused is unchanged to them. And that's nothing particular for them to take any further action or assessment. For that reason, we recommend to have this regular mental health report. Otherwise, we can only work on the existing reports that we have.
So, am I correct in understanding that you were made aware that the accused have a duty doctor and that there's a weekly report on their medical condition, but you've stated that you didn't see an evaluation of their mental condition in those reports? Is that correct?
In the general medical report, it doesn't state clearly on this condition. They only focused on the physical health. However, when we question or interviewed the treating or duty doctors, their impression was that they did not notice that the mental status of the accused is changed.
Would you agree, doctors, that the persons best able to make an initial assessment of the ability of an accused person to be fit for trial to meet those 7 Stugar criteria that you mentioned in your report, that among the people best situated for that evaluation would be the counsel who interact regularly with the accused and can see if they're able to understand evidence and understand the proceedings?
To my knowledge, the mental health assessment by a specialist at a hospital or a Khmer Friendship Hospital, which is the partner of the court, is not mainly focused on the health, on the mental health, but on the physical health rather. And as for the opinion of the defense counsel for the accused, it is my belief that other parties may view that assessment or opinion as non-independent or biased toward their client. Because, of course, apparently they are the defense counsel for the accused. So from other parties' opinion, their opinion or their assessment would be considered prejudicial or biased. For that reason, we would recommend an independent body to make such an assessment, and with that independent assessment, we can use it as a reference in our assessment. Because we have asked duty doctors and security personnel at the detention center, and of course they are aware of the opinion to be provided, as the opinion shall be independent and not biased toward any party to the proceedings. And maybe my partner here would like to add to that.
Yes, I would like to say that the assessment of the cognitive status of an individual has to be done through as many facts that we can receive as possible. Preferably, this would be independent, unbiased facts, and when we are doing the assessment, it is not such a simple process, because there are different domains of the brain that we are actually assessing. For example, we not only have to look at memory, but have to look at long-term and recent memory. We have to look at whether there's any personality change, any thinking, any executive functioning, planning, how about his language, aphasia, apraxia, whether he's able to do things that he's supposed to do, and so forth, which I would think is a bit more complex than just to interact with the council, because you all would be probably concerned about specific areas, and therefore you would only be able to give us information on specific areas. But there are many other areas or domains of the brain that we need to assess before we come to that conclusion of whether a person firstly has dementia or doesn't have dementia, and secondly, whether the person has the mental capacity to attend trial, to follow the proceedings, and so forth.
Doctors, each of you surely has patients of the ages of these accused persons and the general medical condition of these accused persons. In your practice, do you regularly have those patients go through a mental examination, or how often does that occur, and what does it involve normally?
Yes, certainly we have many of such patients. It depends on the situation. I mean, we have to be very practical when we are running our own clinics. We may not be doing the ideal, because it also depends on what are the issues at hand. If we are looking at a generally well elderly who is just here for a single pathology, like hypertension, diabetes, or something like that, and we are not looking at any medical legal issues like person making a will and so forth, then we would only be assessing them at the first point of contact, and probably the next time in a year's time. versus someone who is in the midst of a court tussle, some medical legal issues about lasting power attorney and so forth, then we will have to assess them using different instruments more regularly, because we cannot just keep on using the same instrument over and over again, because there is a learned effect in these instruments.
If I understand your answer, if you had met these persons, accused persons, Nunchi and Kyu Sampan, in a different setting, they were out of custody, they were your patients, you would give them a yearly medical examination, and absent other complaints, that would be it. Is that correct?
Yes, I would.
Thank you. Now, I want to ask you just a few questions about the scheduling questions that were posed to you by the trial chamber. Is it correct, just to summarize your findings, that you both recommended that both accused were capable of sitting 4 days per week in the trial hearings in this case at the present time?
Yes, you're right. 4 days per week, but with the extended break in between, so that they would have adequate rest for the afternoon sessions.
Thank you. And what you're referring to is you indicated that Kyu Sampan had indicated to you that he would prefer an extra half hour at the lunch hour. Is that correct?
That's correct.
Now, just to clarify on that, would it be correct that in regards to the ability of the accused to sit through and concentrate on the proceedings, there are two factors, one being the length of the day of the overall proceedings, and secondly, the length of individual sessions? Would that be correct? That both of those could be factors?
Sorry, can you repeat that question? Thank you.
Yes. My question is, in determining a schedule that accommodates the age of the accused, that there are two factors: the number of hours per day that the accused are in court, but also the length of an individual session without a break. So in other words, whether we sit for 2.5 hours without a break or have 1 hour and 15 minutes with a break, both of those can contribute to both of those affect the issue. Is that correct?
Yes, we believe so.
Is it also correct, you've explained what's quite obvious, that the health of elderly persons is a dynamic situation, and that there certainly is the possibility, significant possibility, that their health will worsen in, for example, 1 year's time? Is that correct?
Yes, that's correct.
So is it correct that any day of court that's lost at the present time we may not or may find it more difficult to make that up a year or more from now because the accused's condition will have worsened? Is that correct?
That's correct.
And just to summarize, assuming that the request of Kyu Sampan is accommodated, that the lunch hour is extended, and that perhaps if the longest individual sitting, in other words, is reduced, in other words, maybe from 2 hours to 1.5 hours, that in your opinions, each of the accused is capable of sitting now in the trial 4 days per week?
That's correct.
Thank you, Mr. President. Thank you, doctors.
President, thank you. And we would like to give the floor now to the Defense Counsel. And the Defense Counsel for Khieu Samphan, you may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. Thank you, experts. I will be brief. I would like to make some remarks and then put some questions to you subsequently. In your medical reports, that of March 2015 and March 2014 and January 2014, you saw Mr. Khieu Samphan only once for 2 hours on one occasion, and again for 1 hour and 45 minutes on another occasion. I'm talking of 2 different occasions, March 2014 and January 2015. On both occasions, you had an interview with them in March 2014 when there were no hearings, and in January 2015 for Mr. Khieu Samphan, after he had spent a few days in hospital. My question to you, therefore, is as follows. As part of a future assessment, would you, the doctors, or any other doctors, not need more data to assess the impact of the duration of the hearings or the number of days of hearings? Wouldn't you need more data after several weeks of consecutive hearings in order to know how the accused would be able to react to such schedules? In other words, from a medical standpoint, do you make a distinction between an assessment of the duration of hearings, as you did it, since we are not talking of fitness to stand trial, the duration of the hearings and the number of days of hearings? Don't you need more data after several days of consecutive hearings in order to be able to gauge the reaction of the accused to the days of hearings and the schedules of hearings?
I hope I could remember all the points that you have made. It's a very long question, but from my understanding of what you have said, you are saying that in the last year's March 2014 assessment, it was in between hearings, so he wasn't subjected to any hearings. And in the January 2015, he had been subjected to hearing, and he had just been discharged from the hospital. I think based on the review of the data that we received, that we reviewed the weekly report data, there has not been very significant changes in his resting vital signs, as opposed to those few incidents where we felt that as a result of sickness or as a result of fatigue, his vital signs went off his normal. Unfortunately, I don't think there are any medical instruments that could measure the impact of trial and so forth on the health of the person. Because if we look at the basic parameters that had been provided to us, his counts were normal, the echocardiogram, which is a reflection of the function of his heart, although it has declined by a bit, if I remembered correctly, in March 2014, his ejection fraction, which is a measure of how much blood, percentage of blood that is being pumped out by the heart was 64%, and now it has declined to 61%, which is acceptable for someone of his age, and it indicated adequate cardiac function in that sense. As I say, our assessment was based on our impression as we talked to him, we interviewed him, and there were times when he got very agitated and he was gesticulating and he was raising his voice. We had to calm him down and so forth. But at the end of it all, when we asked him how he felt, he says, "I'm okay, I can continue. I don't have to break for lunch. We can carry on. I'm okay." So it is based on such feedback that we receive from him that we come up with this, number one. And secondly, in the several times that we interviewed Mr. Q himself, his only request was really to reduce the morning session so that he can have lunch, and after that he can lie in bed for at least half an hour to rest. And then he says that I'm okay. After that, I'm refreshed. I'm able to continue the afternoon session. So he had not made any request to us or verbalized to us that he can't and therefore no, he's unable to participate and so forth. I hope I've answered your question.
Oui, en partie.
Yes, in part. And I crave your indulgence for my lengthy questions. I have another question. In your email of the 8th of January, 319, you state that the heart rate of the patient increases, and when the patient is tired, he feels ill at ease and the blood pressure goes up. My question has to do with subsequent assessments. Is it on the basis of such data that you determine that a monthly or quarterly assessment of the patient should be carried out? Or you have other factors on which you base yourself in making that determination?
I think that recommendation of monthly or quarterly was on the mental state assessment, not the physical assessment.
Et sur la santé.
And regarding the physical health status of the accused, do you have any particular recommendations to make in terms of the frequency of assessments?
I have no recommendations other than to comment that whatever he's having now is adequate from the physical examination point of view.
Je vous remercie, messieurs.
Thank you, experts. I have no further questions for the experts, Mr. President.
President, Mr. Kong Som-on, you may now proceed. Kong Som-on, thank you, Mr. President. I would like to have a few questions in relation to paragraph 42. You mentioned a recommendation that we have to speak clearly and slowly to Mr. Kyo Som-hon. So how slow is it when we speak so that Mr. Kyosompon can listen better and can follow the proceeding?
I would think that the speed at which we are speaking now would be adequate.
Question. Does it has any impact resulting from translation? Is there any complexities in relation to translation that is making him difficult to understand? Dr. Hulina, I believe there is no impact. I believe interpreters are well qualified and they have correct interpretations, so there is no impact. Lord Counsel, I have no further questions. Thank you, Mr. President. And what about Nuon Chea defense team? Mr. Sonorun, you may now proceed.
Some group.
Sun Arun. Good morning, Mr. President, Your Honors, everyone in and around the courtroom. I am Sonorun, the defense counsel for Mr. Nuon Chea. I have several questions for you experts. The first question concerning his backaches. He suffers from severe backache when he moved, and as a result, he also suffered from the headache. Does the two kind of symptoms relate each other? I do not know whether you can provide answers for my question.
Yes, he does have backache, and he does associate headaches and dizziness with his backache, but from the medical point, I don't think there is any correlation. I think it is quite common for people to associate symptoms together, just like earlier on I was mentioning about dizziness and high blood pressure. So in this case, it is the dizziness and the headache with the backache.
Counsel, from my observation, I went to visit and discuss about hearings with my clients frequently, and I observed that the health of Mr. Nuon Chea has deteriorated from years to years. And I could see that his physical condition and mental condition has been deteriorating severely. That is why he has suffered from backache, and he is not able to sit in this courtroom so that he could communicate with parties and everyone. So as you can see, today he is not able to physically present in this courtroom because after he woke up, he had a severe pain in his back. And when he sits in his courtroom, he cannot sit longer than a period of 20 minutes. My next point, I support that there should be a UT doctor specializing in mental condition of Mr. Nuon Chea as suggested by Dr. Hulina. I have no further question, Mr. President. Thank you very much. President, thank you very much. On behalf of the chamber, on behalf of the bench, I would like to express my sincere thanks for your comment and observation and also question during the expert examination. I also express my sincere thanks to counsels for civil parties, co-prosecutors, and defense counsel, staff, security personnel, officers of the trial chamber, and interpreters who have been making this hearing possible. The chamber will take all the points from parties and from experts into account concerning the ability of the accused to join in these hearings. So we now come the hearings on the presentation of medical report of the two accused come to an end, and I thank you, Mr. Experts, who spends your valuable time in appearing in this court as ordered by the chamber, and thank you for giving testimonies before the chamber. As of now, the hearings on medical reports come to an end, and experts can go anywhere you wish to go. I wish you safe trip. Court officer, you are instructed to facilitate with vessels to send the experts to his preferred destination. The chamber wishes to inform the public that in the afternoon, hearings will continue to hear the remainder of Sopani's testimony. The hearing will resume at 1:30 p.m. Security personnel, you are instructed to bring Mr. Kieu Sampon to the holding cell downstairs and have him returned before 1:30 p.m. The court is now adjourned.